with the clear intention to cause him pain, suffering, and death.
Because I just wanted to know how sorry I am for what happened.
That file, he has one conviction.
I need. You know what you did.
In April 2019, 16-year-old Felipe Lopez, a Windsor, Connecticut resident and also a father, was tragically shot and killed in Hartford. Authorities discovered Lopez's body in a crashed vehicle at the intersection of Albany Avenue and Sigourney Street. The investigation revealed that Lopez had arranged to meet with 22-year-old Isaiah Benitez from Hartford, and during the encounter, an altercation led to Lopez's death. The case progressed quickly, and Benitez was arrested shortly after the incident. He was charged with murder and carrying a pistol without a permit. According to investigators, Benitez fired shots during their confrontation. During Benitez's initial arraignment, emotions boiled over in the courtroom. Members of Lopez's family, including his father and twin brother, attempted to confront Benitez, leading to a brief lockdown. Felipe's father and brother were detained, with the father later facing a breach of peace charge.
That file, he has one conviction.
For years, Lopez's family sought justice for the young father's untimely death. In October 2022, a significant development occurred when Benitez pleaded guilty to first-degree manslaughter with a firearm for Lopez's killing. He also pleaded guilty to 2 counts of first-degree assault stemming from a separate non-fatal shooting incident that occurred in March 2019. The legal proceedings concluded in January 2023 when Benitez was sentenced to 18 years in prison, followed by 22 years of special parole. Curtis Flowers, who spent 23 years behind bars for a crime he insisted he didn't commit, has been fully exonerated. At the age of 26, Flowers was fired from his job at a furniture store in Winona, Mississippi. Just 2 weeks later, tragedy struck when the store owner and 3 employees were found murdered. Flowers quickly became the prime suspect, leading to his arrest and a series of trials. Over the course of 6 trials for the same crime, Flowers faced relentless prosecution. Despite a lack of concrete evidence, he was eventually convicted and sentenced to death. However, investigations later uncovered serious misconduct in the jury selection process. Prosecutors were found to have deliberately excluded African American jurors in all 6 trials, raising concerns about racial discrimination. This issue escalated to the U.S. Supreme Court, which ruled to overturn Flowers' conviction due to the prosecution's racially biased actions. After 23 years of imprisonment, Flowers was granted bail and placed under house arrest. His movements were restricted to medical visits and legal meetings, but for the first time in decades, he experienced freedom. Reflecting on his release, Flowers expressed profound gratitude.
I don't know. I'm so excited right now. I can't
Thank you all very much.
Thank you all. Thank you all.
A year after his release, the state of Mississippi made the decision not to pursue a retrial and officially dropped all charges against Flowers. Recognizing the injustice he endured, the state awarded him $500,000 as compensation for his wrongful imprisonment, bringing an end to one of the most prolonged and controversial cases in Mississippi's history. Kimberly Long, a woman wrongfully convicted of second-degree murder, has been fully exonerated after years of fighting for justice. Her nightmare began in Riverside, California, when she returned home and found her boyfriend dead. Acting on instinct, Long immediately called 911, only to find herself accused of the crime and later sentenced to 15 years to life in prison. For 7 years, Long remained incarcerated until new forensic evidence shed light on the truth. The evidence proved her boyfriend had died long before she arrived at the scene and revealed DNA belonging to an unidentified man at the crime scene. This pivotal discovery led the court to overturn her conviction and vacate the judgment.
The judgment of conviction is vacated and a new trial will be ordered.
Prosecutors eventually dropped all charges against Long, ending her legal ordeal. Upon her release, she described feeling a whirlwind of emotions as she tried to process her newfound freedom.
I feel happy, elated, relieved, just a lot of emotions right now.
To compensate for the years she spent wrongfully imprisoned, Long received $386,000 from the California Victim Compensation Fund. Jennifer McKee and Ashley Garul were involved in a tragic case in May 2013. The two women, then aged 18 and 20 respectively, devised a plan to rob Maurice Gonzalez, a 51-year-old man, by luring him with false promises. Their motive was to steal his car, as they were tired of being homeless. Once inside his home, their actions led to his untimely death. After the incident, they wrapped his remains and placed them in the trunk of his car, attempting to dispose of it. Their plan fell apart when police stopped them for a traffic violation, leading to a high-speed chase that ended in their arrest. During questioning, McKee admitted to the contents in the car's trunk, which led to further investigation. In November 2015, McKee, who was 21 at the time, pleaded guilty to charges including second-degree murder and kidnapping. During her sentencing, McKee expressed remorse for her actions, stating,
"I can never really truly express my remorse for the negative actions I have caused, not only to the victim and myself, but to the innocent families of both sides."
McKee was sentenced to 30 years in prison after the judge suspended 21 years from her initial 51-year sentence. Ashley Garul faced similar charges, but details regarding her trial and sentencing were less publicly available. Rebecca Walker, who played a key role in the tragic events that unfolded in December 2020 in Elkview, West Virginia, faced the court's judgment after the heinous acts committed by her then-boyfriend, Gavin Smith. Walker, age 17 at the time, was in a relationship with Smith, who was accused of killing his mother, stepfather, and two younger brothers. During the killings, Walker was on a video call with Smith, reportedly encouraging his actions. Walker pleaded guilty as an adult to 4 counts of accessory after the fact to first-degree murder. Her attorney described her as a grieving girl who, after recently losing her mother, had been manipulated by her boyfriend. Despite this, her actions played a significant role in the aftermath of the murders.
I call the perfect storm. 2 of them became delusional about their futures together.
In court, Walker's remorse had been evident. Too overwhelmed to read her prepared letter, she admitted her involvement and expressed deep regret for the pain she had caused.
I've never read a letter like this.
During her appeal hearing, she had apologized again, stating how sorry she was for her part in the crimes. Her emotions were raw. Though she initially smiled at her family upon entering the courtroom, her demeanor quickly shifted to tears as she addressed the judge.
Speak up.
Because I just wanted to know how sorry I am for what happened.
Judge Ballard, however, denied her request to reconsider the sentence, stressing the severity of the crimes.
This is a senseless act that has rocked this community.
Walker was sentenced to 10 years in prison, a decision the judge upheld during the appeal. Having turned 18, she was soon transferred from a juvenile facility to an adult correctional institution. Meanwhile, Gavin Smith faced his own trial, which concluded in December 2022. Smith, who was 16 at the time of the murders, was found guilty on multiple counts, including first-degree murder. He received 3 life sentences with the possibility of parole after 15 years, as mandated by West Virginia law for juvenile offenders. In September 2024, Abdul Rahim Sulaiman, a 38-year-old Bridgeport resident, was arrested for a violent attack on his partner and her 2 sons in their Main Street apartment. The incident involved the use of a baseball bat, causing severe injuries to both boys. Tragically, the elder one, Jason Escobar, succumbed to his injuries, while the younger one survived with critical but recoverable wounds. Initially, Sulaiman faced charges of attempted murder, assault, risk of injury to a child, and criminal possession of a weapon. However, following the death of the Jason, charges were elevated to include murder with special circumstances, a charge carrying a mandatory sentence of life in prison without the possibility of parole. The courtroom proceedings highlighted Sulaiman's history of disruptive behavior. He assaulted judicial marshals and frequently caused disturbances, leading to additional charges of assault on a public safety officer and disorderly conduct. During court appearances, Sulaiman initially appeared calm during his arraignment, where he entered a not guilty plea to all charges and requested a jury trial.
You understand all that?
Yes, Your Honor.
The courtroom atmosphere, however, shifted quickly after the formal proceedings concluded, with verbal exchanges between Sulaiman and Jason's family adding to the emotional weight of the case.
I expose you any day. Any day. You know what you
Mr.
did?
Suleiman, you look at me, and everyone please, I know there's a lot of emotion, but this needs to be quiet.
Jason's uncle, who has been vocal about the family's grief, described the loss as an unimaginable tragedy and emphasized the family's hope for a just resolution.
I wanted to wring my hands around his neck, but I wasn't able to. Our family is really going through tragic time right now, and we just want justice for our nephew, Jathan Escobar.
Courtroom testimonies revealed a history of violence in Suleiman's past, including prior convictions in both Connecticut and New Jersey. In 2012, he served 7 years in New Jersey for aggravated assault. In Connecticut, he had prior convictions for assaulting a police officer, risk of injury to a child, and violating a protective order, which resulted in a 2-year prison sentence followed by 4 years of probation in 2022. However, for recent charges, Suleiman remained in custody with a bond set at $11 million. In 2016, a devastating tragedy shook southeast Shelby County when Shenanthea Gardner was charged with the deaths of her 2 sons and 2 daughters. The case unfolded in their apartment home, where Gardner was arrested after the gruesome incident. Her eldest son managed to escape and called for help. Only he survived. During the trial, Gardner's defense team argued that she was experiencing severe mental health issues at the time and believed her daughters and sons were in danger. They claimed she was not in her right mind when the murders occurred and mounted an insanity defense. However, the court ruled that despite her mental deficiencies, Gardner was aware of her actions when she committed the killings. The charges against her included 4 counts of first-degree murder, aggravated child abuse, and aggravated child neglect. The court heard emotional accounts and arguments from both sides before Judge James Lammy delivered the sentencing. Gardner was given life sentences for each murder conviction, with the possibility of parole, along with 15 years for each of the additional charges. These sentences were set to run concurrently.
Count 1, I find you guilty of first-degree murder. Sentence you to life with possibility of parole.
In practical terms, Gardner must serve 51 years before becoming eligible for parole. With 5 years already served since her arrest, she will be around 80 years old when she can first seek release. The sentencing brought a sense of closure to the prosecution, who described it as justice for the 4 innocent lives lost. The father, present at the sentencing, chose to remain silent but expressed quiet resolve in the outcome. Ruth Kamande, crowned Miss Langata Prison in 2016, faced the Nairobi High Court for the murder of her boyfriend, Farid Mohammed, in 2015. At the time of the crime, Kamande was a 21-year-old business student enrolled at Jomo Kenyatta University of Agriculture and Technology. The court highlighted her deliberate actions, revealing a clear intent to inflict pain, suffering, and ultimately death.
I find that the accused person deliberately stabbed the deceased with the clear intention to cause him pain, suffering, and death.
During the trial, the court dismissed Kamande's mitigation, which failed to demonstrate any acts of despair or anguish leading up to the murder. Instead, it was determined that her actions were calculated and intentional. The judge remarked on the seriousness of the crime, pointing out the danger of resorting to violence in moments of personal frustration or disappointment.
And I've taken into account, I want young people to know that it is not cool to kill your boyfriend or girlfriend, even where you feel disappointed or frustrated. Don't do it. Instead, it is cool to walk away and thereafter to forgive.
In a stern message to young people, the judge emphasized the importance of walking away from toxic or strained relationships.
Now, after considering all these factors, I find that the only sentence to pass in this case is death, and therefore sentence the accused person to death as prescribed by the law.
Concluding the case, the court sentenced Kamande to death as prescribed by Kenyan law for such offenses. Mohammed's family expressed relief and gratitude, acknowledging the ruling as a just outcome. In October 2024, Memphis authorities discovered the body of a woman, identified by acquaintances as Rochelle Hill, in a wooded area behind her residence on Peppermill Lane. Her son, 24-year-old Dylann Roof, was arrested and charged with first-degree murder, abuse of a corpse, tampering with evidence, and resisting arrest. During his initial court appearance, Roof exhibited defiant behavior, including eye-rolling and profane outbursts, particularly when the charge of abuse of a corpse was mentioned. He was also seen smiling in his mugshot. The presiding judge informed him that if convicted, he could face the death penalty. Rose was ordered to be held without bond and assigned a public defender.
Sad. It's sad.
Neighbors expressed shock at the incident, describing Hill as a friendly individual who often hosted gatherings. They noted that Rose had a history of mental health challenges and previous run-ins with the law, including charges of stalking and intimidation in 2019. As of now, Rose remains in custody, awaiting further court proceedings. A mental evaluation has been ordered to assess his competency to stand trial. In November 2023, a devastating tragedy unfolded in Cleveland when Braylon LaFleur was fatally shot near East 93rd Street in Edmonds. The perpetrator, 16-year-old Steven Sopko, carried out the crime with chilling intent, leaving Braylon's family to grapple with an unimaginable loss.
This is not a video game. This is real life. This is not Grand Theft Auto. I have to be my son's voice. And it's tragic.
As the case progressed, the courtroom became a somber setting for justice to be served. Prosecutors highlighted the deliberate nature of the act, portraying Sopko's actions as far beyond a mere lapse in judgment. Despite being only 16 at the time, Sopko was tried as an adult due to the severity of the crime.
I don't blame his mother. I don't blame his father. I blame Steven because in life you learn right from wrong.
This is a sentence that's meant not only to protect the public, but to punish you for this cruel and brutal offense. It's way beyond youthful indiscretion or bad judgment.
Sopko offered little explanation for his actions, leaving the reason behind the murder unclear.
I wanted him to say why. I think the world want to know why.
Braylon's mother, speaking through tears, recounted the profound void left by her son's absence. She described Braylon as a vibrant, loving boy with a promising future, a young man who brought light and joy to those around him.
He just was the life of the party, the smile that lit up the room, y'all. I promise y'all. If y'all would have met him, y'all would have loved him.
Holding on to the last physical memories of her son, she mourned the life stolen from him and the potential extinguished by the tragedy.
I'm gonna truly miss my child. No, I really am.
While the defense has announced plans to appeal the conviction, Braylon's mother expressed a sense of closure. For her, this marks the end of one painful chapter as she continues her journey of grief and healing, holding tight to the cherished memories of her beloved son.
Your sentence will be life with consideration for parole after 31 years.
After carefully weighing the evidence, the judge delivered a life sentence for Sopko, allowing for parole eligibility only after 31 years. This decision, aimed at both punishment and public safety, ensures that Sopko will not have the opportunity for release until his late 40s. While the defense has announced plans to appeal the conviction, Braylon's mother expressed a sense of closure. For her, this marks the end of one painful chapter as she continues her journey of grief and healing, holding tight to the cherished memories of her beloved son. In April 2019, a tragic event occurred in San Antonio, Texas, where 37-year-old Jeanette Quiroz and her 18-year-old pregnant daughter, Bernadette Quiroz, were fatally shot outside their apartment complex. Bernadette's newborn, delivered via emergency C-section, sadly passed away shortly after birth. Authorities arrested a 14-year-old boy in connection with the murders. Due to his age, his identity was not disclosed. At the time of his arrest, he was already in custody on an unrelated aggravated robbery charge.
Typically, you don't see someone as young as 14 being subject to adult certification, but the law does allow it in extreme circumstances, and certainly this would be one of them, where a person as young as 14 is charged with capital murder.
The Bexar County District Attorney's Office faced the decision of whether to try the suspect as an adult. Texas law allows for juveniles as young as 14 to be tried as adults in extreme circumstances, but the death penalty cannot be sought for individuals of this age. Prosecutors emphasized the severity of the case, but stated that they would make a determination after reviewing all evidence and reports.
Again, we're going to wait till we have all the final reports before making a decision how to best proceed in this case. And I'm not sure that would be the appropriate result in any event for a 14-year-old to be subject to capital punishment. But in any event, we have other options available to us.
Family members of the victims expressed profound grief and sought justice for the lives lost. Bernadette's family remembered her as a vibrant young woman with a promising future, and Jeanette's life was described as devoted to her family. The double tragedy left the community in shock and mourning.
This court believes that you may be a danger to yourself or to others, and you possibly may be a flight risk.
The boy was charged with capital murder, and a detention hearing was held where Judge Arcelia Trevino ordered that he remain in custody, citing the potential danger to the public. As of the most recent updates, the juvenile suspect remains in custody, and legal proceedings are ongoing. A decision on whether he will be tried as an adult had not been publicly announced. In August 2013, a devastating DUI crash in Miami, Florida, took the life of 22-year-old Irina Reynoso. The driver, Mila Dago, was operating a rented smart car when she ran a red light at the intersection of Biscayne Boulevard and Northeast 15th Street, colliding with a pickup truck. Tragically, Reynoso, who was a passenger in the car, died instantly. At the time of the collision, Dago's blood alcohol level was measured at 0.178, over twice the legal limit. Prosecutors presented surveillance footage reportedly showing Dago running the red light and striking the truck. Investigators disclosed that Dago had been highly intoxicated and texting her boyfriend throughout the night during a breakup. She had sent more than 60 text messages, including ominous statements like, "I'll be dead thanks to you," and "You'll be the death of me." One of her texts, sent just minutes before the collision, read, "Driving drunk woo."
It's upsetting because it highlights how preventable all of this was. Ms. Dago clearly knew she shouldn't have been driving.
Reynoso, who dreamed of becoming a law enforcement officer and was attending Miami-Dade College, left behind a grieving family, including her only sibling. The victim's family described her as a free spirit with a beautiful soul.
She was a beautiful, beautiful soul. She was a free spirit.
The victim's family also filed a civil lawsuit against Car2Go, the vehicle-sharing company from which Dago had rented the smart car. They argued that safeguards should be in place to prevent intoxicated individuals from accessing vehicles through such services. Car2Go has since stated that they would review their policies in light of the incident.
You can rent at 3 o'clock in the morning without speaking to an attendant, just on a whim. That's something that lends itself, unfortunately, to having folks under the influence pick up these vehicles.
Dago's defense attorneys indicated that she plans to use her experience to advocate against drunk driving upon her release, aiming to raise awareness and prevent similar tragedies in the future. In December 2015, Mila Dago pleaded guilty to 1 count of DUI manslaughter as part of a plea agreement. She was sentenced to 4 years in prison, followed by 10 years of probation. Her driver's license was permanently revoked, and she was ordered to perform community service. In October 2023, a tragic family dispute unfolded in Cleveland, Ohio, leaving one brother dead and the other facing decades in prison. Rodney Curley, 19, fatally shot his 23-year-old brother, Tymere Hale Dial, during a heated argument while helping their mother, Pinky Hale, move into her new home on East 127th Street. The day began as a family effort to assist with the move. According to testimony from their mother, Rodney and Tymere had a history of sibling squabbles, and the argument that day seemed like another minor disagreement. The dispute began inside a U-Haul truck parked in the driveway. Witnesses, including their mother, recounted that Tymere made a comment mocking Rodney, saying, "You're nothing without your gun." Rodney responded, "I shoot to kill," and drew a firearm. Rodney fired shots, initially hitting Tymere, despite Tymere's attempts to de-escalate the situation. Rodney continued to fire, ultimately shooting him. Witnesses described how the shooting unfolded while Tymere's family members were nearby. After realizing the severity of his actions, Rodney fled the scene, leaving his brother fatally wounded.
Is the defendant Rodney Curley's brother? He is older. In meeting with Ms. Hale throughout this case and in speaking with her, it's the state of Ohio's understanding that they were moving. Ms. Hale had acquired a new house, and that she had actually been with Rodney for most of the day, moving their furniture, their belongings, in a U-Haul. She says Tymere was actually at work and came to the house to help aid them in the moving process. She says they fought like normal brothers do, and on this day, she said she was in the house. Mr. Curley and Tymere The victim are in the U-Haul, which was actually parked in the driveway in front of the house. You can see it in the crime scene photos. And that they were just arguing back and forth about where to put things in the house, where things should go in the house, and regular brother stuff. Ms. Hale tells me they come into the house, the argument continues. She doesn't think much of it because she said they're brothers. They always used to argue about little things, and she didn't think much of it. She said she was in the kitchen with Tymir's 1-year-old child. He had a 1-year-old child at the time. And she says they go back out into the U-Haul. She hears from the window that the argument continues, so she actually steps outside to go intervene because they're just arguing, and she said we were new in the neighborhood and we hadn't even been there a day and they're doing their brother stuff. She indicates to me that Tymir made a statement to his brother, Mr. Curley, you're not anything without your gun. And Rodney's response was, I don't fight, I kill. I shoot to kill. And ends up raising the gun and his brother in the shoulder while she, Ms. Hale, Tymir, and Rodney are in the back of the U-Haul vehicle. Ms. Hale indicates to me that Tymir jumps down, is laying on his back, and basically says, all right, knock it off, and Mr. Curley continues to shoot his brother. She said he shot a couple of times in the front, and Tymir turns over to try to get away, and she says, her exact explanation to me was Rodney unloaded his clip on his brother. She indicated to me the gun was pointed at her. That is why we have the count of felonious assault from Ms. Hale. And at that point, it's almost like Rodney realized what had happened and runs away. Tymir is eventually shot 16 times. He has 16 gun wounds that the ME counted. And he is dead when the police arrived.
The Cleveland Police Department launched an immediate investigation. On November 16, 2023, Rodney was apprehended by members of the Northern Ohio Violent Fugitive Task Force at a residence on Rayburn Road in Cleveland. He was found hiding in a basement and surrendered without resistance after officers announced the use of a K-9 unit. Rodney was charged with involuntary manslaughter, felony assault, and aggravated menacing. During court proceedings, he pleaded guilty to the charges and expressed genuine remorse.
When I first met Rodney, he realized what happened, realized that he had to take responsibility for this from day one. I'd like to point out that my client has one misdemeanor, and that's it. He's been with Jim and I, he's been very respectful, honest, and has expressed remorse, and knows that he did what was wrong. Within 2 minutes, a family's life has just changed forever, and it's just sad. And I guess I would, Ms. Hale, when she said she loves her son, I think that's awesome. And so I think that would, with that, a sentence at the lower end would be appropriate. And then I think, when I talked about 2 minutes, that it just changed. I think what Ms. Vaca said sort of summarizes this case. All of a sudden, Rodney realized what he did. I don't think he really, obviously he knew what he was doing, but I think he just snapped. And there was a violent outburst, as we pointed out in the sentencing hearing.
He admitted that he blacked out during the shooting and only realized the full extent of his actions the following day.
So, Mr. Curley, it's such a disturbing case, and there's so many moments that you could have made different decisions, from walking away from an argument to not pulling out a gun to even stopping at one bullet. Why did you keep shooting? If you don't know, you can tell me you don't know. I'm just curious, do you know why you did?
Judge, he said he blacked out.
When did you realize that you'd killed your brother? The next day? You didn't realize that he was likely dead when you ran?
His mother, caught in the heartbreaking position of grieving one son while supporting another, addressed the court.
I just want to make it brief. I just really want to say.
It's okay, take a deep breath. Okay, breathe. Take all the time you need.
I just really want to say that I love Rodney so much. I love him so much. And I hate that all this is happening. I love Tamir so much, and I miss them both so much. And it's just a terrible, I don't even know what to say. It's terrible. But that day was the worst day of my life. Because I knew that day I was losing both of my sons. I just can't live like this. And I know he did what he did, and he ruined my life. And he took Tamir's life, and he ruined his own life. He's so young. And I just want to let him know that I love him. No matter what, I love him. And I miss him every day. I miss Tamir every day. But that's all I want to say.
Okay, thank you.
The emotional weight of the case was further emphasized by testimony about Tamir's life.
Ms. Hale, throughout this process, has always been very respectful, very forthright about what happened, very willing to come in and testify. But she also always indicated to the state of Ohio she didn't want Rodney to lose his life in the way that Tamir did. You know, that life was a tough sentence for her and her family, but that anything lower than 18 to 20 was going to be a slap on the wrist, that Tamir's life would have meant nothing then. When I asked Ms. Hale what Tamir was like, she said he was a ray of light, a breath of fresh air. She said he was always willing to help family members, he was always there. He had a job as a security guard at a local school, and that the school actually shut down for the kids to mourn him when his death occurred. She said he was a good father. She said even though him and Rodney had their squabbles, she thought he was a good brother, and that Rodney and Tamir were night and day. You know, she knew Rodney had problems, kind of running in the street, getting into trouble, getting, you know, into the bad crowds, but you know, she always had indicated to me her love for Rodney, but that he took something away from her family that can never be replaced in her son Tamir. And now, like she has addressed to you, both of her sons have lost their life. So the state of Ohio felt that the range was appropriate given Ms. Hale's feelings and the family's feelings and what happened. We don't want it to diminish Tamir's life, but she was always adamant if we don't have to go through everything and replay everything with the trial, she would be okay with these ranges. So that is how we got this case. That is the facts of what happened. And so we ask you to sentence within that range. When I speak with Ms. Hale, there's not a specific number that she gave me. She says no amount of time can be put on Tamir's life, but she also realizes that Rodney's going to have to do that time, no early release, so she felt whatever the court felt was appropriate given the facts of this case. So given that, we don't have a specific number other than within that range. I do know initially Ms. Hale had felt 20, anything less than 20 was maybe diminishing the offense. However, she realizes, you know, Rodney trying to minimize his exposure as best as possible. So given that, we would defer to the court within that range of 18 to 25 years. We ask for facts.
He was described as a loving father, a kind-hearted individual, and a reliable family member who worked as a school security guard. His death left a significant void in the lives of his family, friends, and community. His mother also expressed her hope for justice, stating that while she didn't want Rodney to receive a life sentence, anything less than 18 years would feel like a disregard for Tamir's life. On the day of sentencing, Cuyahoga County Common Pleas Judge Holly Gallagher emphasized the severity of the crime and the lasting impact on the family.
Count 7, which is the misdemeanor of the first degree, you're sentenced to 120 days in county jail with 120 days served. That sentence is completed. On count 3, the felony of the first degree, the base of the sentence is 10 years with a 3-year gun specification, which is to be served prior to and consecutive to any other term imposed. Reagan-Tokes does apply to this count, 5.5 years. PRC is mandatory minimum of 2 to 5 years on that count. On count 4, which is the base merges with count 3, so I'm not sentencing on the base. However, I am sentencing on the gun specification, which is 3 years, to be served consecutive to the sentence imposed in count 3. Count 6, a felony of the second degree, the base of the sentence is 4 years, plus the 3-year gun specification. That gun specification also be served prior to and consecutive to the base and consecutive to the sentences imposed in counts 4 and 3. This is a total sentence of 23 years. Post-release control is applicable on counts 4 and 6 for a mandatory minimum of 18 months to 3 years. As I stated, Reagan-Tokes, I'm sorry, it's 5 years, not 5.5, is applicable on count 3. And as I explained to you at the time of your plea, that enhancement of the sentence is entirely within the discretion of the Ohio Department of Rehabilitation and Correction. You understand that, right? If you violate the conditions of post-release control, the parole board must impose an additional prison term for up to 1/2 of any prison term that I've imposed. So your definite sentence is 23 years. With the indefinite portion of Reagan-Tokes, it is 28 years. Fines, fees, and costs are waived.
Despite Rodney's genuine remorse and lack of prior felony convictions, the court determined that the seriousness of the offense required a significant sentence. He was sentenced to 23 years in prison with no possibility of early release. The sentence included mandatory post-release control, ensuring oversight upon his eventual release. Sean Lowry, a 46-year-old resident of Brecksville, Ohio, was involved in a tragic incident on July 29, 2023 that would have lasting consequences. Driving his GMC Acadia at speeds exceeding 120 miles per hour on Interstate 77 South near East Pleasant Valley Road in Independence, he collided with 45-year-old motorcyclist James Billings. The crash resulted in Billings' death, and instead of stopping to help, Lowry fled the scene.
He did. Had he been thinking about it, being intoxicated, driving 127 miles an hour down the highway, I believe you can expect to cause physical harm to persons or property.
Investigators quickly identified Lowry as the suspect. Evidence revealed that he had been driving under the influence at the time, further compounding the seriousness of his actions. His decision to leave the scene of the accident became a central focus of the case. These actions led to charges of attempted involuntary manslaughter and failure to stop after an accident. As the case unfolded, details of Lowry's criminal history came to light. Over the years, he had been convicted of several offenses, including assault in 1997, disorderly conduct in 2015, and multiple charges in 2017, including attempted abduction, domestic violence, and criminal damaging. At the time of the incident, Lowry was on probation for a previous offense of physical control of a vehicle while impaired. This probation stemmed from an April 2023 case in which he was sentenced to 180 days in jail, with 177 days suspended and required to complete a chemical dependency assessment. His involvement in the July crash represented a violation of that probation, further complicating his legal situation.
In this case, in fact, the defendant was on community control for a physical control. That physical control sentence was imposed on April 6, 2023. The defendant was given 180 days in jail, and 177 of them were suspended, and he was given probation with the condition that he complete a chemical dependency assessment. So, in fact, that making recidivism more likely factor does apply. The defendant has a history of criminal convictions or juvenile delinquency adjudications. In fact, that is true as well. Mr. Lowry has a conviction for assault on January 7th, 1997. Disorderly conduct in 2015, attempted abduction in 2017, and domestic violence, criminal damaging in 2017. Those were all part of the same case. Domestic violence in 2016. Then the physical control that I've already mentioned. Attempted drug abuse in 2023, April 6th as well. And then this case. And then after this case, the defendant picked up a subsequent DUI. So yes to whether he was on community control, yes to history of criminal convictions, yes to not responding favorably to sanctions imposed because this is a violation of his probation in the physical control case. Yes to showing a pattern of alcohol use related to this offense, and he eventually got treatment, but it wasn't till after the DUI that came after this case.
On March 27, 2024, Lowry appeared in court and pleaded guilty to attempted involuntary manslaughter and failure to stop after an accident. During the proceedings, he expressed genuine remorse, acknowledging the harm he had caused and apologizing to the family of James Billings. He admitted to struggling with alcohol dependency, which had contributed significantly to his reckless behavior.
I do find the one factor that the defendant does show genuine remorse. Quite frankly, it is something I never see in this courtroom. Somebody who comes in and absolutely takes responsibility for what they did and in fact admits to the things that we all know happened but didn't have enough proof. That never, if ever, happens in here. Whether recidivism is less likely, I do not find that he has, well, he doesn't have any prior juvenile cases. He does have prior adult convictions. He has not led a law-abiding life for a significant number of years. I do not believe the offense was these circumstances could occur again. I do find, however, that he shows genuine remorse. That is striking to the court. Whether or not people believe that or not, that's up to them. I've sat and presided over hundreds, if not thousands, of sentencings where individuals absolutely refuse to take responsibility and admit to their conduct. I don't find that that's the case here.
While Lowry's remorse was noted, his extensive criminal history and repeated disregard for the law required a significant punishment.
That a sentence must reflect the magnitude of the harm that was inflicted. The counts will run concurrent. Count 5, 11 months. Count 1, your minimum sentence is 7 years. Your maximum sentence is 10 and a half years. All right, you're ordered remanded and transported.
On May 9, 2024, Cuyahoga County Common, Pleas Judge Holly Gallagher sentenced Lowry to serve between 7 and 10.5 years in prison. The judge emphasized that the sentence reflected the seriousness of the harm caused and the need to protect the public. Following the sentencing, Lowry was transported to the Lorain Correctional Institution to begin serving his sentence. His earliest eligibility for release or parole is March 25, 2031. Eric Ivey had dedicated nearly 3 decades of his life to public service, working at the Cuyahoga County Jail. Over the years, he earned leadership roles, eventually becoming the warden of the facility. However, his career took a dramatic turn when the jail's internal problems and his actions became the focus of a serious investigation. By 2018, the Cuyahoga County Jail was under scrutiny for poor conditions, overcrowding, and inadequate medical care. Reports of systemic issues, including drug use among inmates and preventable deaths, began to surface, drawing attention to the facility's management. Among the many troubling incidents, the death of Joseph Arquillo, an inmate, marked a pivotal moment. On August 28, 2018, Arquillo passed away from an opioid overdose only hours after being booked into the jail. Investigators discovered that he collapsed and showed signs of distress for an extended period without receiving medical help. Experts later concluded that timely medical intervention could have saved his life. During the investigation, it was revealed that Ivy had instructed staff to turn off their body cameras at the scene, which prevented the recording of crucial evidence. This decision raised significant questions about transparency and accountability within the jail.
Your Honor, Mr. Ivy pled guilty to obstructing justice, and the underlying case that was at issue for the obstruction count was a death investigation of an inmate who died in Cuyahoga County Jail on August 28th. The inmate was Joseph Arquillo, and he died of an opioid overdose. He had been in the county jail for about 10 hours and ingested the opioid sometime between his arrest and when he died on the 28th. Mr. Ivy showed up at that death scene, and guards who were at the scene notified the state during the death investigation that Mr. Ivy had ordered them to turn off the body cameras as this inmate was being recovered from the pod. That's important for a couple different reasons. This death investigation focused on whether anyone in the jail had fault for this death, because the inmate was still alive as much as an hour and a half after he collapsed from his overdose. And a careful analysis of the video shows that the inmate was still breathing, struggling to breathe, approximately 40 minutes before Mr. Ivy showed up at the scene. That's important because the failure to summon medical treatment was the focus of the investigation. The guard on duty had gone over to this inmate as he has collapsed, and you see that in the photos, and it basically kicked the mat and walked away. And as the photos will show, and the video will show, which we have in court, this inmate was still alive when that happened, and had medical care been summoned, it's the state's contention that this inmate in all likelihood would have lived. The guard who was on duty at the moment, at almost the precise moment this happened, and you'll see it in those photos that we provided you from the security video, was reading the Cleveland Plain Dealer, and he falsified records. The death investigation focused on that conduct. The body cameras, which were at issue, would have captured the audio from the witnesses who were at the scene. We don't have any audio because Mr. Ivy gave an order to the sergeant in charge of the jail. And the sergeant in charge of the jail, what he said to Mr. DeSimon on April 17th, this is Mr. Ivy's statement, we can't film these because if we don't do something right, this is helping the civil lawsuits. We don't want to film these. And this was in the context of these deaths that were occurring in the Cuyahoga County Jail. That same day, April 17th, Mr. DeSimon went from that interview directly to Mr. Ivy's office and interviewed Mr. Ivy and confronted Mr. Ivy about this order that he had apparently given to not have body camera footage from these death investigations. And what Mr. Ivy told Mr. DeSimon was, oh, we have a policy not to film because of HIPAA. Mr. DeSimon immediately asked for the policy, and Mr. Ivy couldn't produce it because there is no policy. The order had been given based on what we found for the precise purpose of preventing evidence from surfacing in these death investigations and civil lawsuits. And when we questioned guards further, the two guards who were at the scene, and you see them in the video there, Officer Barthany and Officer Pritchett, they said they had destroyed the body camera video on orders, which we would have had these orders not been given. The body camera, we find, is vital in determining fault in these cases, and without it, we have very limited ability to understand what happened and then present the cases in court.
Following the incident, the U.S. Marshal Service conducted an investigation into the jail, uncovering broader issues of mismanagement and unsafe conditions. These findings, combined with Ivy's involvement in the Arquillo case, led to criminal charges. In early 2019, Ivy, who had already been demoted from warden to associate warden, was charged with obstruction of justice and falsifying records.
The condition at the time of the plea that he testified truthfully, you believe he has done that, and the plan was another condition was that he would be resigning on the date of sentencing, and you expect that to be the case. Is that correct?
I do, Your Honor.
All right, very good. And his continued cooperation with you is expected as well.
That's correct. Thank you, Your Honor.
Anything else?
One moment. No, thank you, Your Honor.
Thank you. Okay. Mr. McDonough?
Thank you, Your Honor. Please, the court, counsel. I think it's important to note that
No, I appreciate my colleague's narrative of the facts on the day in question, but we're not here because Mr. Ivy made an order to destroy evidence or destroy body cameras. He made a poor lapse of judgment and advised subordinates turn off your body cameras while we have this conversation. It also is important to note that Mr. Ivy was the 13th person to actually arrive on scene while other medical staff was providing assistance to the inmate at that time. Aside from that, I would agree with Mr. Meyer. My client took accountability and responsibility for his actions as evident by his change of plea, his constant cooperation with the Ohio Attorney General's office, as well as his resignation. And I can attest to the court, as well as I provided to counsel earlier today. I've already reached out to the Cuyahoga County Human Resources Department to schedule a meeting today. Mr. Ivy's resignation letter has already been drafted, approved, and we're just merely waiting for that meeting to occur. Your Honor, I hear that these are serious offenses and any crime is serious. Mr. Ivy has worked in the public sector for over 28 years with an unblemished record. He's been constantly promoted to positions of responsibility and of leadership, leading multiple individuals. And it also should be noted that aside from his public service working for Cuyahoga County, he also worked for the United States military for over 5.5 years. It's extremely important because that references and demonstrates Mr. Ivy's leadership. Also, I believe there's no contestation that Mr. Ivy doesn't have a criminal record, misdemeanor and or felony. And one moment of a poor lapse of judgment now attaches to his long tenured reputation in this community. He acknowledges that, he accepts responsibility and accountability. However, taking accountability, stepping up, leading by example, and then with no dispute from the state of Ohio, and then hearing that a jail sentence is appropriate for Mr. Ivy, I just think that is unwarranted and unsubstantiated. I would ask the court to reflect on Ohio Revised Code 2929.21 as well as the factors in 2929.22. There's no reference of holding a first-time offender to the water or to the fire for future cooperation, make sure he's on probation or committing criminal sanctions. I do not think that's necessary. I think my client is resigning from his tenure position, cooperating willingly, has already cooperated with the state of Ohio, consistently, unwavering. As such, I think that the appropriate sentence should be court costs and or fines.
In October 2019, Ivy accepted a plea deal, admitting his actions were a serious error in judgment. During the sentencing, his defense highlighted his lengthy career, his cooperation with investigators, and his previously clean record, and asked for leniency in sentence.
Assume full responsibility for my actions and the decisions that I've made. For the last 28 years as a correction officer, I've prided myself in being a good leader, leading by example, helping those I can help in order to be successful. I'm also remorseful to the fact of the embarrassment, the stress that I've caused to my family, to my friends, to Cuyahoga County, and all those who have looked up to me over the years as a mentor and a leader. And I want to strive to continue to be that leader. So with that being said, Your Honor, I just want to say that as I stand, I accept full responsibility for my actions. I have the utmost remorse. This has caused me my entire career, something I've worked extremely hard for. I had a position that was my dream job. And due to the poor decision that I made, I accept those responsibilities. I just want to make that known to the court.
Ivy also addressed the court and expressed remorse for his actions and the impact they had on his reputation, career, and community.
Requires additional cooperation. I'm going to sentence you to county jail in counts 1, misdemeanor of the first degree, 180 days, count 2, misdemeanor of the first degree, 180 days. Counts will be served concurrently. The sentence is suspended. You're placed on probation You would be, number one, the risk of this happening again. I think you have severely breached the public trust. I think you know you have done that. And what you have done is serious. There will be rolling ramifications here on the civil and criminal side. But your decision-making in this case appears to be uncharacteristic with the good years, the many good years you served the county. So I am disappointed in you. We expect more of our public servants, don't we?
Yes, ma'am.
All right, so, and I'm going to place you in this group for 1 year to ensure future cooperation with the state. You'll be eligible for early termination or extension based on your required performance for the state until your cost and fees. You'll report today and then every 6 months thereafter to the probation department, but technically you're on probation for this year. The court will impose 200 hours of community work service for that breach of trust. You'll pay the costs. Costs become a judgment against you. If you fail to pay them, you may be required to perform community work service. Additionally, fine $1,000 on each count, and supervision fee is $20 a month. You will testify truthfully upon request of the state, and you will resign from your employment effective today, October 3rd.
The court sentenced him to a suspended 180-day jail term, 1 year of probation, a $2,000 fine, and 200 hours of community service. Additionally, he was required to resign from his position at the jail. The judge acknowledged Ivy's years of public service, but emphasized the breach of trust his actions represented. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.